And welcome to this second knowledge clip in the constitutional law course, in which I explain and illustrate some of the key concepts in the Heringa book. Now this week we're talking about the origins and the main features of constitutions. And if you talk about the origins of constitutions, you talk about the origins of power. And here a key concept is that of sovereignty. Sovereignty can mean many different things. You can talk about the sovereign as the king. You can talk about a state's sovereignty in international relations. You can talk about sovereignty as the theory of the philosophical foundations of power. But here when we talk about the sovereign, we mean the place, the institution that holds the original power, where power comes from and where power flows back to. Now, classically, in many countries, and even before there were countries, the sovereign would be the king, the monarch. We talk about monarchical sovereignty. And a key feature of many of the 16th and 17th century, the 18th century revolutions, for instance in Western Europe and the United States, was about checking the power of the king, the absolute power of the king, and replacing it with the idea of popular sovereignty, the idea that the people as a whole are the original holders of power. We, the people of the United States. The idea here is that this is where sovereignty emanates. Now, different constitutions have different ideas on where this original power lies. In Belgium, for instance, sovereignty is said to lie with an abstract entity, with the nation, which means that there's no referendum because the original power does not lie with the people, but with the nation, for instance. There's other countries where sovereignty is said to be based in the legislature, so the legislator as the elected representatives of the people. For instance, the UK is very well known for the idea of legislative sovereignty, but to be true, the actual system in the UK is that of the two houses and the king together holding this legislative sovereignty. In federal states, it's important also to distinguish in looking at the sources of original power. If we see this as a federal state, then many federal states, for instance the United States, would say that the original power, the sovereignty, lies with the states in the US who have given power to the federal state, but whatever they haven't given to the federal state still lies with them. So that's the concept of state sovereignty in a federal state. There's also some countries who do not speak about the idea of sovereignty at all, where you can't derive from the constitution who actually put in place the constitution, who has the original power, like the Netherlands. It just remains unclear there. So sovereignty can reside with different entities, but one thing that you see in all constitutional democracies that we speak about is that power is subsequently divided over different bodies. So this is the Montesquieu idea of the separation of powers. Let's first look at the role of presidents in constitutional systems. Basically, there's a main distinction to be made, and that is between presidential systems, so say this is the president in a presidential system, or a parliamentary system. Now, in a presidential system, the president has separate executive powers of his own. Might be accountable to all kinds of bodies, but has constitutional powers given directly to him or her. In a parliamentary system, there might be a prime minister, or the person might be called a president, as in Germany, but the president is directly accountable to parliament, to the legislature. So power in a way is derived from parliament. Then you also have a semi-presidential system where you have both a president and a prime minister, both elected directly, and the prime minister accountable towards parliament, as is the case in France. So that's the main distinction: presidential and parliamentary systems. In all systems, you'll see the idea of a separation of powers. Now, you all know the classic understanding of the separation of powers as discussed by Montesquieu in L'Esprit des Lois, where he says, well, you have on the one hand the executive, the government basically, you have the legislature, parliament, who sets the laws, and you have the judiciary who controls the laws and who in that sense provides a check. And this doctrine in the separation of powers, you can say there's different systems of it, but this holds true for all constitutional democracies. There's always this functional and at times even personal distinction between the separation of powers. So it can be that it's impossible to be in government and at the same time be in parliament, for instance, like in the US or in the Netherlands. But it's also possible that actually the government is in parliament and remains in parliament, like the United Kingdom, where ministers also sit in the House of Commons. So there's different systems there in terms of personal division. But one thing that you see in all countries is that the judges, the judiciary, has to be independent and impartial. So you never see a judge also being a president or a judge also sitting in parliament. This is a main feature of the rule of law. And the idea of the rule of law is that power, whether it lies with the government or the legislature or together, is only there if it has a legal basis and has to be checked by law everywhere it does. Now, coming back to this separation of powers, as I said, there's big differences. One big difference is really about the role of the judges, which I've put here. And one key competence, one key power judges can or cannot have is to review acts of parliament against the constitution. So to check on the constitutionality of what the legislature, what parliamentarians have decided. In the US, if you talk about this power of constitutional review, in the US, all judges have the power of constitutional review. So they can all check acts against the constitution. In some countries, like Germany or South Africa, this power of doing a constitutional check is vested in the Constitutional Court. So only the Constitutional Court has this power. In France, there was never something like this, but in 2008, Conseil Constitutionnel, the Constitutional Council, was given this power of constitutional review. There's only, there's others, but there's two main countries in the Western world that don't have the power of constitutional review, and the Netherlands, where we are, is one of them. So in the Netherlands, judges are not allowed, are actually prohibited from reviewing acts against the Constitution. And this has to do with ideas on legislative supremacy, that the legislature in a way goes above the judges. So big differences between countries in the separation of powers, and at the same time each constitutional democracy has a system of checks and balances. I'm trying to do a triangle here. Checks and balances in place. So the legislature checks upon the government has checks upon the judiciary on the government, the judiciary on the legislature, legislature on the judiciary. So this is to ensure that nobody in the end has absolute power. Apart from these checks, if we talk about the national government, one way in which power is also divided, to make sure that nobody has absolute power, is over the different subnational units of government. So here you can imagine this is the nation state, but as said, every nation state has subunits, and sometimes it's the subunits, the federal, the states that have original power, they have sovereignty, which they then share with or give to the national governments. And in other states, it's the nation state that has the power, which it can then devolve to subnational units. Well, systems in which the nation state has the power and devolves it, this we call unitary states, and states in which the federal system dominates, where states have separate independent powers given to them by the Constitution, this we call federal states. So in federal states, this is an additional check on the power of the central government. Federal versus unitary states, also a very important distinction. If we talk about sovereignty and we talk about who has the original power, a question in the European countries we're looking at is what the position of the EU is, and how the idea of Europe relates to the idea of sovereignty, whether with the legislature or with the government, or populist sovereignty or elsewise. And here many countries have come up with a construct in which they award sovereignty, they transfer powers to Europe, often with a separate clause, as is the case in Germany and France, or with an act, as is the case in the United Kingdom. So this is how it works with Europe. Well, there's a lot more to say about the division of power and about the checks and balances that there are in every constitutional system, but I hope that I've explained to you the headlines, the main points on key issues like sovereignty, the rule of law, constitutional review, unitary and federal states, and in the European context about placing power with the European Union. And I very much look forward to discussing this in class with you. Thank you. Bye-bye.